LGB. 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 LGB.
They say LGB everywhere I go. LGB. What it means, I don't know. LGB. Whatever it is. LGB. Come on, help me, please. Please.
Alrighty then.
Thank you. LGB.
That's let's go, Brandon, right?
LGB.
This means let's go, Brandon.
Go. LGB.
Sounds like let's go, Brandon, I guess.
LGB. All right. Let's go, Brandon.
I am Cornholio.
Chant LGB. Right wing and left wing. LGB. Go, you know the thing. LGB. If you don't sing, that back. LGB. And you ain't black. LGB.
Let's go, Brandon.
LGB.
Let's go, Brandon.
LGB.
Let's go, Brandon.
FJB. Let's go, Brandon.
I'm Joe Biden, and I
Forgot
this message.
Greetings, my dear friends, and welcome to another episode of Reading Epic Threads. I'm your host, Patrick Gunnels, joining you from Houston, Texas, this February 3rd, 2024 at 1:53 p.m. Central Standard Time. So this show is going to be all about the Martin Geddes articles that I have allowed to pile up over time. So the saga of him versus the Durham County Council, understanding what it is to be lawful as opposed to legal, understanding the ways that our government, seizes our rights and then sells them back to us as privileges. So we're going to do a few articles from Martin, hopefully somewhat catching up, and then maybe do another one tomorrow and do the same thing. But before we do any of that, don't forget to go to, and this is a new thing, guys, angelpaste.com is one system, and I have a Shopify system that is connected to a website called epicthreads.tv. And believe it or not, the way we're doing it now is we're manually entering every order that comes in through the angelpaste.com website, manually entering it into the epicthreads.tv system, which is based on Shopify. It's an entire workflow process that we can get rid of if you order directly from epicthreads.tv. So right now, you can buy individual bottles of rose-infused angel paste from epicthreads.tv. Click on the angel paste collection in there. I'll show it to you right now. So check this out. We have epicthreads.tv, and I have clicked on the angel paste collection. So it's epicthreads.tv/collections/epicbeauty. That URL could be shorter, but we'll figure it out from there. But in any event, you can get your angel paste miracle cream unscented. It's currently marked as sold out. So if you want to get the angel, it won't be sold out when we, at the time that you are watching this, it will no longer be sold out. We'll be changing that. And then, of course, rose angel paste, a bottle of rose-infused angel paste, which, guys, those of you who watch this show, you can buy them now individually at epicthreads.tv. And it also makes it a lot easier on us when you buy it from epicthreads.tv because we don't have to port over the order information into a different system. So please go to epicthreads.tv, use promo code Shapiro to pry $1 from my grasping hands. And of course, if you get 3 or more bottles, if you get, here we go, 3, it's free shipping on $150 plus. So if you get 2 bottles of rose, you get free shipping. Bam! 3 bottles of angel paste unscented. Bam! Free shipping. So just check it out on the epicthreads.tv website. I'm always open to suggestions about the functionality of the site. It is a work in progress, but as we attempt to add more products to our line, we really want to have a system where we don't have to port over the name and address to a separate system. All right, so angelpaste.com is not the place I want you to order at right now. We got to figure out how to port these two systems together. So epicthreads.tv, and then just click on the Angel Paste collection. I'll show you how that works real quick, and then we'll get to our articles. EpicThreads.tv, here we are. Then you click on the word Angel Paste, and there you go. Not too hard, right? All right. So that's that. Now, without further ado, let's begin with an article from newsletter.martingeddes.com all the way back from January 12th. From newsletter.martingeddes.com, holding Durham County Council to account lawfully, even if very slow. Another small step forward to demolishing the council tax mega fraud by Martin Geddes. Pictured here, a letter from Martin Geddes to John Hewitt, Chief Executive, Durham County Council. I have just got back from Durham after hand delivering a notice to the Chief Executive of Durham County Council with a witness to it being delivered. There is a mucky satisfaction to this small achievement, as the corruption inside the envelope leaks a stink onto its handler. This act moves me 2/3 of the way through the 3-notice estoppel process. This process, once complete, prevents Durham County Council from making any future claim that a council tax liability order exists and that there is an enforceable debt. That, in turn, opens the door to me suing them for damages for endlessly harassing me without lawful authority and allows me to expose more of the underlying giant fraud involved. Here is what I just delivered for the public record so others can also follow this same process. The previous notice is here, link in the article. I hope that this is useful and educational, even if it isn't the most riveting Friday evening reading. Our local government agencies have degenerated into organized crime, and it is incumbent on us, the ordinary people, to hold them accountable. We must persevere, no matter how many roadblocks those who are meant to protect us put in the way. The use of fake courts to enforce fake orders for fake debts is abhorrent. A lot of people in high places deserve long prison sentences for misconduct, fraud, theft, and treason. Time-sensitive document. Estoppel conditions apply. 12th January 2024. To John Hewitt, Chief Executive, Durham County Council. Notice to agent is notice to principal. Notice to principal is notice to agent. Failure to rebut is acquiescence. Opportunity to cure. I delivered by hand a notice to your main reception on 17th November 2023 in the presence of a witness. That notice contended under estoppel conditions that an alleged liability order may lack lawful authority. I therefore demanded proof of claim that it exists and thus visibility of the claimed authority. As no response has been forthcoming, it is presumed that you acquiesce with it not existing. Hence, you agree to waive any claim to have authority to enforce any purported debt. As you may be aware, there was a landmark High Court ruling by Judge Harrison that was published on 21st December 2023 in the case of Wayne Layton versus Bristow and Souter 2023. This ruling was in the context of council tax debt owed to the City of York Council. Judge Harrison ruled that Tribunals and Courts Enforcement Act 2007 demands proper authority before enforcement, that the debtor is entitled to see such authority on demand, and that enforcement without said authority is unlawful. In this case, it resulted in an award for damages to Mr. Layton. Furthermore, Judge Harrison raised the possibility that liability orders do not constitute proper court orders, with the order being a misnomer, and that the enforcement process may breach ECHR Article 6, European Commission on Human Rights, Article 6. You have written notices to me in 2022 and 2023 claiming to have a liability order. On both occasions, I have asked to see proof of claim, and therefore evidence of authority, since I dispute the underlying constitutionality and lawfulness of these administrative tribunals. You have declined to acknowledge every single request for due process, let alone provide it. Accountability is essential to authority. Without it, there is an open invitation to lawlessness. Instead, Durham County Council has continued to harass me for money without any lawful authority to do so, falsely treating me as vexatious for seeking due process. As such, I enclose your latest unlawful correspondence outside of due process. I am returning it to you to rebut its assertion that there is a valid debt that can be enforced in the absence of the correct paperwork. The lack of any named man or signatory on this correspondence is further evidence that you are aware this is unlawful and seek to evade personal accountability. I assert that this matter is not merely an attempt to enforce a debt with a defective order. Rather, your conduct is a willful evasion of the law by systemic design, constituting a premeditated and malicious scheme to extort money under duress. Durham County Council has been placed on notice on multiple occasions and asked to cease and desist, yet you persist in unlawful enforcement without let-up. Judge Harrison ruled that attending a property is not trespass where the order is merely defective, but in this case, your agents are acting in the full knowledge that their conduct is unlawful from the start, as there is no paperwork to offer nor authority to act. You are notified that any agents, whether your own CDOS staff or representing a third party, knowingly sent without authority, are engaged in aggravated trespass and will be held individually liable along with Durham County Council. Failure to rebut within 7 days will be deemed further acquiescence to my assertions regarding the unlawful nature of your council tax liability order, debt enforcement, and the lack of authority to act. Without ill will, vexation, or frivolity, by Martin of the Geddes family, PP Mr. Martin Geddes, sui juris. End of letter. The sign-off differentiates me, Martin, the living man, from Martin Geddes, the name and dead legal fiction. The man is signing on behalf of the fiction. Their account is in the name of the fiction. The whole system is based on coercion and fraud, tricking people into taking liability for matters over which they ought not to owe anything. Another week from now, I can deliver the final notice of default. A week later, I am in a position to file full notice of my claim, and a few weeks after that, I can file my court action. It's a lot of paperwork, but we now have powerful and recent case law on our side. They will have little chance of persuading any court that their actions were lawful and legitimate. These Marxist bureaucrats hoped to grind us down, so we give up. Sorry, not happening. You're too evil and allied to the child traffickers embedded into social services, so we will never back down. I and many others are in this to take back our communities from their greedy grasp, not evade paying our bills. So keep pressing forward. The corruption and theft will stop if we insist on it in sufficient numbers. And that is the first one of multiples that I'm going to get all squared away for y'all. All right. Make sure that I've got everything under control. All right. Let's do the next one. But don't forget, guys. Okay, so this is important. You need to go to epicthreads.tv to buy stuff in general, but you can buy it. And this is the important part. Angelpaste.tv. Did I already close it? God, so obnoxious. I'm so bad at this. Where is Epic Threads? Did I freaking close it? God, I am freaking insufferably stupid. Okay, 1 second. I'm opening it up again. Epicthreads.tv. I should have it open at all times. So what you do is you go to epicthreads.tv, and there you are. Plenty of things you can get. Epic merch, the blog, which we haven't put together yet, but Angel Paste is right at top. You can get the Angel Paste Miracle Cream or the Rose Angel Paste, both in individual bottles now. And you can do that if you get more, if you do buy more than, $150 worth. So, 3 Angel Pastes or 1 Angel Paste unscented, and then, or 2 Angel Paste unscented, 1 Rose, whatever. These are the two SKUs that are currently available at epicthreads.tv. Helps us enormously when you order from here because it automatically enters the order into our system. As it stands right now, there are two separate systems that we don't sync up automatically. So this epicthreads.tv is really what we need you to sign up for. And so we're offering Rose Angel Paste individual bottles exclusively through that. So definitely check it out and your skin will drink it up. All right, so instead of closing, I'm going to stop sharing. And now we'll go back to Martin Geddes. But first, before I do that, I'm going to go to his next article. Okay, so the next one is Equity is how you can bring your creator to court. How interesting is that? From newsletter.martingeddes.com, equity is how you can bring your creator to court. We have to appeal to a higher authority than the state in order to defeat communists. By Martin Geddes. As part of my personal pushback against the abusive and thieving administrative state, I am appealing to the Traffic Penalty Tribunal against my penalty charge notice for having dared to drive my, quote, car-derived van into Newcastle and desiring to be treated the same as all other cars on the road. This is a case about the fundamental right to be treated equitably in one's use of the highways. I have put together the following outline argument to the judge. I am testing whether this administrative tribunal will allow me to make my case based on the rules of equity. These rules are founded in the notion that we are all created equal by a creator and therefore must be treated the same by the law where all else is equal. I am not being treated the same. My Ford Escort van only differs in appearance to a Ford Escort saloon, hatchback, or estate car. As a result, my freedom to travel is being eroded. You may find this case helpful in putting together your own pushback. As I tend to do, this is a draft I am sharing before submission so I can hear what contributions and improvements readers have to offer. I only have comments turned on in Substack for paying subscribers. All the content is free to everyone, but anyone who reads this from the email can just hit reply to get back to me. 1. Newcastle City Council, hereinafter NCC, has implemented a clean air zone, CAZ, rules that elevate the form of my conveyance, van body type, over its substance, Ford Escort engine, and chassis used for private non-commercial travel in a discriminatory manner. By being in opposition to the principles of equity, it crosses a red line, unfairly penalizing the appearance of my car for which there is no legislative or lawful authority. 2. There are other matters of breach of common law principles, human rights law, and international treaty obligations on non-discrimination, but this equity matter is the pivotal point to be ruled on. 3. The determination in question is the administrative classification of a car-derived van, as recorded by DVLA, as a van rather than a car. The dispute over whether it is a car or a van represents a corner case. This is not the first time a tribunal has faced this kind of determination, to which we return below. This is not a challenge to the lawfulness of clean air zones in general. The dispute is restricted to this one matter. 4. On the one hand, we have clearly fully private travel in a standard car that is exempt from the CAZ, Clean Air Zone, charge, and on the other, there is driving a specialized fully commercial vehicle that is presently charged. There are situations where the facts and the rules are in tension and could fall either way. 5. Is the boundary of our apex corner case drawn too inclusive of one side or the other? This situation is precisely what equity addresses, allowing for nuance rather than mindless application of rules in ways that contradict morality and reason. 6. The controversy that equity resolves is whether NCC has the ultimate lawful power to categorize and tax the use of my conveyance as if it were a commercial goods vehicle when the facts say otherwise. This is in the context of my car being factually operated in solely a private capacity for social, domestic, and pleasure use. 7. Can NCC lawfully and not merely legally differentially charge me compared to other travelers in, say, Ford Escort Saloon, Estate, or hatchback cars, whether these models are compliant or not with the CAZ emissions standard is moot. The sole issue is whether there is lawful authority to treat this conveyance and me as a traveler on a differential and potentially discriminatory and thus unlawful basis. 8. This case is about A, protecting the private individual's right to travel without hindrance on the public highways, B, protecting his right to choose the style of his conveyance as long as it causes no harm or loss to others, C, respecting fairness and equity and making and the determination of the trade-off of the rights and obligations of the parties involved. 9. Parliament does not have the power to regulate purely private matters, like the style of my conveyance, nor the power to create two privileged classes of travelers in an inequitable manner. More on this below. That is why we differentiate between law and legislation, as some legislation is unlawful due to its discriminatory, immoral, or unreasonable nature. 10. The essence of the NCC case is a conflation of legal and lawful, using primary, secondary legislation and administrative policy to bypass hard constraints on legislative and executive power. These limits on power include case law, constitutional law, international treaties, and especially the rules of equity. 11. For every infringement of basic civil rights, equity principles, or case law, there may be a new administrative rule, e.g., we declare that how you use or insure the vehicle is not a cause for exemption. These rules are impeccably enforced, and there is no suggestion here that the NCC has done anything other than follow its own rules to the letter. 12. Unfortunately, that does not make NCC's actions lawful, only temporarily legal until overturned by case law, judicial review, or tribunal verdict. This all comes down to where authority to act arises from, and the sovereignty of the people, each man or woman being of infinite worth, with Parliament as the people's servant, not their master. 13. As such, the relevant standard for adjudication is lawfulness, as in England we enjoy the rule of law, not the law of rules. However, the adjudicator may feel about a transgression of the strict rules when those rules lack a chain of authority that goes back to our Creator. His or her duty is to uphold the law, which is rooted in a higher and holy authority. 14. To elevate policies like how DVLA turns vehicle type into CAZ, vehicle type, above truth and morality, is to put administrators into a position of ruling authority over society, which is unconstitutional as well as immoral. 15. A foundational principle of law is that we are all equal, unless our Creator can be brought into court to testify otherwise. This is the root authority that equity flows from, and why equity, i.e. an implied appeal to our Creator's authority, is above Parliament, and is the determining framework of law in this corner case. 16. We must still treat others as we would be treated ourselves in comparable circumstances. Natural moral law comes first in the pecking order. Equity aligns to that natural moral law and holy principles and limits Parliament from straying outside of it when legislating, thereby becoming tyrannical. 17. We may have registered our birth and our vehicle and obtained a driving license. As a consequence, we may be deemed to have entered into commerce with the Crown. None of these things can overturn the superior claim of being a man and deserving of equal treatment. 18. In this case, I am firstly a living man, being a traveler in my private conveyance. I am also attached to the legal fiction Mr. Martin Geddes, whose name appears in the court proceedings and is the registered keeper. Equity applies to both the living man and the legal fiction. I offer this filing and plea as a living man, standing on behalf of the legal fiction. 19. In the context of Boris Johnson asking to prorogue Parliament, the UK Supreme Court ruled in 2019 that A, both the legislature and executive remain bound by the rules of equity, B, that Parliament is only sovereign over the executive and remains an agent of the people, thereby constrained to act in their interest, and C, that the Bill of Rights 1689 still applies, hence Parliament may do nothing to the detriment of the people. 20. That there are limits on the power of the legislature, including equity, is not some archaic and outdated concept. No legislation can permit one man to treat another man in a way he himself finds iniquitous if the roles were reversed. That is to elevate Parliament above our creator and sacred morality. 21. Moving from limits on power to more technical matters, this is not the first time a tribunal has been asked to rule on a corner case of categorization for tax purposes. A famous and relevant example, but not binding as case law, highlights the central issue of form versus substance under the rules of equity. This is the case of United Biscuits, UK Limited, versus Customs and Excise, 1991. 22. Are McVitie's Jaffa cakes considered to be cakes and exempt from value-added tax as an essential good, or chocolate biscuits, thus subject to a 20% VAT as a luxury item? The tax man argued that they were packaged like biscuits, sold like biscuits, eaten like biscuits, made by a biscuit company, and the public, when polled, said they were biscuits. Yet, McVitie's carried the day by the facts that they were made from cake batter and went hard when stale, like a cake, and not soft, like a biscuit. A Jaffa cake is a cake, not a biscuit. 23. The equity principle here is as follows. What mattered in the tax category determination was the literal substance of the issue, i.e., what it was made from, cake-like, how it was used, biscuit-like, and what it became, cake-like. 2 out of 3 was enough to make it a cake for tax purposes, a status that benefits Jaffa cake connoisseurs like myself to this day. 24. How the product was presented or marketed were only issues of form and thus subsidiary. The opinion of third parties was not a sufficient determining factor either, be it public opinion polls or DVLA. 25. The parallels to the matter of whether my conveyance is an untaxed private car or a taxed goods van are easy to discern. Is my car-derived van a cake, car, uncharged, or biscuit, van, charged? 26. This analogous case translates into our presenting situation as follows. My personal carriage is made from the same basic components as any other Ford Escort car. It is being used and insured the same as any other Ford Escort car in private personal use, and its exhaust emissions are the same as any other Ford Escort car. All 3 point to it being a Ford Escort, i.e., a car's chassis and engine, not a goods van, mere appearance, for the purposes of clean air zone enforcement. 27. How it was originally marketed, or how its seats and cargo space are organized, are only superficial form in respect of clean air zone enforcement. Form alone does not justify regulation and charging. There must be supporting substance. 28. This is the essential quality that determined this case. The substance of my personal and private conveyance is car, while its form is van. Substance trumps form in equity law. This leaves the tribunal no residual discretion to apply the letter of the rules that NCC imposes without regard to fairness or reasonableness. 29. If there is no substance to NCC's claims, express or implied, that I am operating a goods vehicle that causes harm to others in a way that justifies differential treatment, then their claim must be dismissed on the basis of equity. 30. Indeed, the rules of equity and obligation to treat all men equally has biblical roots, and arguably this claim to regulate my car as a van breaks the mandate to love thy neighbor as oneself. If the boot was on the other foot, I would expect that a similar position to my own would be taken by the claimant's representative or the tribunal adjudicator. 31. This PCN also crashes against the Ten Commandments and the prohibition against stealing, since common sense and everyday manners say that I deserve equal treatment with a Ford Escort, saloon, hatchback, or estate driver. There is accountability to our Creator for pursuit of legal cases made on a knowingly immoral basis, regardless of the judicial outcome. 32. In classifying a car-derived van in private use as a van, NCC and DVLA are attempting to transform its van style into the substance of a truck, like a Transit or Luton, which you might call a van-derived van, or even into a specialist commercial vehicle like a JCB-type digger or 52-seat coach. This is a logical absurdity and again violates the principles of equity that prefer facts and rationality. It is also a form of conversion, which again points to it being unlawful. 33. The underlying logic appears to be some commercial vans are in frequent use and cause a lot of pollution, joined to you are driving something that looks like a commercial van to infer you are causing a lot of pollution. This is a false inference. Not all vans are in commercial. Mine is not commercial, and mine is not in frequent use in cities. NCC could have used an objective measure like vehicle weight, but chose not to. 34. If NCC asserts that my car-derived van is necessarily involved in commerce because it may be useful for moving goods, the burden of proof is on them, and thus far no evidence has been offered. After all, many ordinary saloon cars are used in commerce, but there is no presumption of that being so. This presumption of acting in commerce based only on form goes against the facts of my case and again opposes equity. 35. This type of conversion between private car and commercial van has been justified by NCC on the basis of data laundering through the DVLA as a third party blaming the DVLA and transferring responsibility. The vehicle type was only ever collected for the purpose of driver and vehicle licensing. The data field is correctly descriptive of the static physical conveyance itself, say, should the police wish to identify it, but that is all it is. 36. This data field has been extended by NCC to infer its nature when deployed in operation, both in terms of its emissions class as well as its commercial nature. This is to impute information that is not there. It is an either-way general-purpose conveyance that can equally be used privately or in commerce. This over-extrapolation breaches the GDPR requirements for data to be accurate, transparently obtained, fairly used, and limited in purpose. By breaching a number of core data protection principles, NCC undermined their own case. 37. It is worth pointing out that applying the CAZ charge to a private car-derived van is iniquitous in another relevant manner. For the road tax, DVLA charge a car-derived van the same as a car and less than any form of commercial goods vehicle. The road tax has reflected emissions for a number of years. That DVLA itself treats a car-derived van the same as a car is further evidence, should it be needed, that the McVitie's precedent applies. 38. There is also a form of double dipping with the CAZ fee. It may be triple dipping with a tax on diesel fuel. The CAZ differential pricing for a car-derived van is enrichment, violating equity once again, since it is based solely on form, not substance. Whatever public harm my Ford Escort may cause during highly infrequent trips to Newcastle, that is already accounted for through these existing levies. There is no suggestion my conveyance is anything other than compliant with emissions standards for ordinary private domestic use of the public highway, which this travel constitutes. 39. The problem of NCC sourcing its data from the DVLA categorization runs even more deeply. A pedal cycle can be operated commercially, e.g. Deliveroo, and likewise a motorcycle, e.g. Courier, or even a horse and card, e.g. Rag and Bone Man. While it may be reasonable to presume a specialist tool like a crane is for commercial use only, this is clearly untrue across a swath of types of conveyance. The term van in ordinary use simply refers to a wheeled wagon with a load space. There is nothing intrinsically commercial about a motorized wagon with 2 seats that can haul a modest cargo. 40. The CAZ rules appear arranged around the deficiencies in the data available, such as not knowing its insurance type, commercial or non-commercial. They are thus drawn overbroad to include everyone possible in order to evade addressing the distinctions that affect the civil liberties of some travelers, for which there is no supporting computerized data available. This is unfortunate, but does not justify unfairly penalizing the few who occupy the gray zone, where the data is ambiguous or uncertain. 41. To summarize the equity argument against this PCN, it is iniquitous because it A, elevates form above substance, B, unfairly penalizes a traveler without a balancing public interest, C, constitutes enrichment, as others in factually equivalent circumstances are not charged, D, fails to achieve a fair balance of interests by treating what is substantially a car the same as the largest and most polluting HGV vehicle. E, lacks fairness in how administrative data is obtained and processed. 42. Taken together, this charge is functionally equivalent to a no rear windows tax on my private car. There is no law that enables NCC to extract a charge on this basis. 43. As noted in my original presentation, this discriminatory policy of treating a car-derived van as a commercial goods vehicle, irrespective of the facts of its substance and use, violates superior law through international treaties that the UK is party to. Specifically, it violates the European Commission on Human Rights Articles 2 and 14 on travel and non-discrimination, and ICCPR Articles 2 and 12 on non-discrimination and freedom of movement. There is no public interest in regulating the aesthetics of my car that permits these constraints on statute law to be ignored. Equity is sufficient grounds to dismiss this PCN, but these additional constraints force this matter. NCC is not above international law. 44. NCC make the argument that I've consented to their rules by passing their signage. This falls afoul of hardened case law, specifically Ollie v. Marlborough Court Hotel 1949, where the law lords made it clear that you cannot impose terms after the fact. At best, the sign infers, quote, someone may be charged for something, no penalty announced or agreed to. 45. This is a known and potentially existential problem for all clean air zones. Since they present no opportunity to inspect terms, there is no signposted alternative route, and no penalty charge is notified in advance. These are not rules of the highway itself, but peripheral to the physical act of safe travel while operating a motor vehicle. Clean air zones are not part of the highway code, do not form rules of the road itself, and are not intrinsic to the safe sharing of the public highway. 46. These CAZ charges appear to be in a constitutional limbo. They operate under public environmental law, but have the look and feel of criminal fines or forfeits subject to long-standing constitutional limits of due process that ensure mercy. This includes Magna Carta, 1297, Clause 29, the Statute of Marlborough, 1267, Clauses 1 and 4, and observance of due process of law, 1368, Clause 3, all being currently in force to this day. It is not to be obtuse by referring to ancient law, but to highlight that the matter here concerns some of our most long-standing freedoms and customs, including unhindered travel on the public highway, that are protected by the Coronation Oath Act 1688, Section 3. 47. Meanwhile, CAZ charges take up the clothing of commercial law, presenting as being a contractual agreement in nature, yet lack essential properties thereof, such as consideration. It can be reasonably argued that commercial vehicles operated as parts of fleets are subject to a different standard, as the fleet manager owns the problem of compliance. That is not a reasonable burden to place on the private individual traveler, now forced to research every journey before undertaking it in order to see if new charges or rules have been imposed. 48. The signs at the entrance to the CAZ have the form of road signs in terms of font and reflective style, using the information format, but are legally roadside signs. There is no obligation for a driver focused on safety and navigation to prioritize attention to them. This is problematic in this case. Where did free will agreement occur? Were the terms plainly and transparently presented? Is any discriminatory charge lawful given this context? 49. There has been no notice to me personally of the terms before passing the signage, or opportunity to consider whether I wish to pass in my car-derived van or challenge or clarify this policy in advance. I have passed the same signage on a previous occasion while the scheme was not yet in force and got no PCN. I do not have a television, I do not listen to radio, and I do not take any newspapers. I do not live in Newcastle and do not visit it often in my car. I have received no personal advance notice from NCC in any form before undertaking this personal and private journey, as it happens to help a friend collect lost luggage from the railway station. 50. That the finer points of cars versus vans can be considered at speed on a dual carriageway in unfamiliar surroundings lacks elementary sense. All other road signs, e.g. bus lanes, speed limits, no entry, disclose their full semantics via their symbology and are immediately actionable, so do not impede the overall ability to reach the final destination on an equitable basis. 51. These new CAZ charges are complex quasi-contractual relationships with fine distinctions based on vehicle type that vary, e.g. between London and elsewhere. They are not rules of the road in the same way as other regulatory signage is, and are closer to turnpikes without toll booths or turning spaces. But turnpikes had toll booths, and the carriages were pulled by horse, so could easily turn back. 52. Either the signage is the disclosure of full terms and represents a fair and reasonable agreement, or it is not. NCC cannot have it both ways. Is there anywhere signposted that you can easily locate to make such a check if you are a corner case, as is my own situation? Lawful agreement requires a meaningful alternative to consent. Otherwise, it is just unlawful entrapment dressed in legal costume. 53. Are you actually being forced to carry an internet-connected laptop everywhere, so you must turn off and research the law in a lay-by every single time you approach one of these signs? Do you have to stop to check even if the CAZ doesn't apply to you? That appears to be the implied suggestion, which is a remarkable imposition on our established common law freedom to travel wherever we want. 54. As the last matter on the matter of disclosure and agreement, the Newcastle and Gateshead CAZ website states that private cars are exempt. Whatever the underlying policies and procedures based on DVLA data, my private conveyance is a Ford Escort, which is foundationally a car and is being used as such. That I have chosen the 2 seats, huge boot, easy to secure Ford Escort car variant is my business alone. 55. As there is no substance to differentiate a car-derived van from a car when in private use, it being discriminatory, there is no basis for this PCN. Since I am reasonably entitled to interpret this website as ordinary English and therefore have been directed not to pay a charge, I did indeed check the website after my journey and interpreted it this way. To force a perverse interpretation of my Ford Escort car being a commercial goods van when it is factually not, in substance or operation, is unreasonable. 56. By ruling on the less contentious basis of equity to dismiss this PCN, I argue that it ultimately supports the lawfulness of clean air zone regulations. While it may constitute a tactical loss to NCC, who may have to adjust their rules for this exception, it is a strategic win, since it reasserts that the program as a whole operates under the rule of law. This, in turn, reinforces its legitimacy in the eyes of the public, including these tribunals as checks and balances on power. A reasonable compromise of an affidavit of private use has been offered to NCC, which does not limit their ability to enforce their rules upon others. 57. These zones are controversial, and many perceive aligned to a wider political agenda that erodes long-standing freedoms, acting as a form of private enclosure movement of our last major common space on land, that being the public highways. Submitting to equity law confirms the intent to comply with our constitutional settlement and preserve our historic customs. Respect for equity signals that we are a society where the public still have redress against overreach of power by authorities, especially where individual liberties, like the right to pick a small car-derived van as your daily transport, are at stake. 58. NCC are attempting to differentially charge based only on the form of my conveyance and not its substance, which denies my right to choose the style of my conveyance as long as no loss or harm is done to others. This right is not to be casually dismissed. This particular conveyance with a low loading height suits me personally. No matter what administrative rules are in place, this is unlawful since it breaches a fundamental principle of equity, which is to prefer substance over form. It is an overreach of legislative and executive power, no matter how presented. 59. This case is about a foundational freedom to travel without let or hindrance while being treated on an equitable basis with other private travelers. There is no evasion of the CAZ fee. The shape, color, windows, doors, and cargo space configuration of my private car are simply none of NCC's business to regulate or tax. 60. To rule otherwise is to claim we have a two-tier society where some, the administrators, are more equal than others, the administrated. To facilitate unfair enrichment of the former at the expense of the latter. This is nakedly unconstitutional as it violates the Bill of Rights 1689. We are all equal under the law, and Parliament does not have any power to create master-slave relationships. This tribunal is under oath to uphold the law, and each party is bound by the rule of law. 61. Unhindered travel on the public highway is a common law right also protected in constitutional law, notably by union with Scotland Act 1706 C1 Article 4. Being forced to research every journey or stop to check terms on every journey in a highly inconvenient manner, regardless of these terms apply to you, is an unreasonable burden on travel. This is especially so as the charge only relates to the style of my conveyance, all other things being equal. 62. Finally, to destroy the Constitution is treason. R versus Thistlewood, 1820. Knowing failure to uphold all law under judicial oath is a serious matter. This includes fundamental constitutional law that asserts our equality as men and women and freedom to travel equitably. So in other words, guys, Martin is not really all that interested in being jacked around with by administrators. This is incredibly detailed arguments. Go to newsletter.martingeddes.com. Newsletter.martingeddes.com. Subscribe, buy some of his stuff. Go to martingeddes.com/support. Do what you can if you have the means. This is what Martin does for a living. He got drummed out of the tech world for being one of those, crazy MAGA patriot Q followers. So it's kind of up to us as a community to support the work that we so deeply need done in this world. All right, don't forget to go to epicthreads.tv. That's epicthreads.tv and click on Angel Paste, which is up at the top, and you can buy individual bottles of rose-infused angel paste. And man, there's nothing in the world that smells like this. God, I can't get enough of it. You can get it individually, so check it out. Your skin will drink it up. Use promo code Shapiro to pry $1 from my grasping hands. $150 or more, and you get free shipping. We also have merch, damn fine merch. You can get some of my challenge coins from the older Threadfests. That's kind of cool. The globalists can all go to hell. I have gone to Texas. That's from Threadfest 2. Kiss the Truther. We have some mugs. We have some t-shirts, one that says Be Epic. So check that out as well. But Angel Paste is the main draw here, guys. So you can get both the rose and unscented. Get whatever you like. Just click on it. Angel Paste. Add it to your cart. Add to cart. Boom. Now you got it on your cart. In your cart. Go back to Angel Paste. Add a rose. You can add it to cart. Bam. Now you got rose and unscented in your cart. So definitely check that out. All right. Back to Martin. I think I'll do one more piece from Martin. And then I'll call it a show. All right. So backing up. Bam. All right. What's this one? How traffic tribunals end run the rule of law. Again, Martin Geddes. From newsletter.martingeddes.com, how traffic tribunals end run the rule of law. Legal minds have been applied to evading constitutional requirements for due process. By Martin Geddes. I have a video tribunal hearing for a traffic penalty coming up at the end of January, and I wish to make my case based on higher forms of law, equity, constitutional limits on power, international treaty obligations. The matter is of considerable public interest since fundamental principles of liberty are at stake. Do we have any redress against local authorities and the commercialized state when it overreaches its power and treats us differently in exercising fundamental rights without any balancing public interest? I wrote to the Traffic Penalty Tribunal asking some elementary questions. From the letter, Dear Sir or Madam, Question 1. Can you confirm that adjudicators operate under the standard judicial oath issued by the Lord Chancellor to uphold English law? If you have a copy to hand, that's a bonus, but not essential. Question 2. Can you point me to the rules that the tribunal operates under? As these are civil cases, do the civil procedure rules still apply, or is there a different set of rules on evidence, due process, appeals, etc.? Question 3, specifically, what is the accommodation for observers on the video hearing? Publicity is the very soul of justice, as the famous saying goes. Thank you for your assistance. Martin Geddes. My assumption was that these were operating as lightweight courts of law, but I was wrong. Here is the response. Dear Mr. Geddes, thank you for your email. The adjudicators are lawyers appointed under the terms of the Road User Charging Schemes, Penalty Charges, Adjudication and Enforcement, England, Regulations 2013. The adjudicators form a local authority tribunal. They are not part of HM Court, I suppose His Majesty's Court, and Tribunal Service, and do not take a judicial oath. The relevant regulations and more information can be found by visiting our website, trafficpenaltytribunal.gov.uk, funding and legislation. We confirm that the hearings are public hearings and any member of the public may observe a hearing on request. Yours sincerely, the Traffic Penalty Tribunal. Note the standard tactic of no real man or woman being accountable for what is said. So we have lawyers who are moonlighting as quasi-judges, paid for by one side of the case, and who have taken up no oath or obligation to uphold the law. They also fail to give actual instructions on how observers may join, just to leave more hurdles to cross. The regulations list a series of reasons why adjudicators might dismiss the penalty charge, but there is no room to challenge the lawfulness of the regulations in the first place. As such, these tribunals are treasonous, since they act to strip us of our constitutionally protected right to due process. When a barrister with an oath to a private guild acts as adjudicator, they are drumming up business for their profession and proving the form of justice without its substance. So, time to dig deeper. Thank you for your helpful response. I have read the regulations you referred to and have some follow-up questions. Do adjudicators agree to any undertaking to uphold the law, bearing in mind that the law includes more than primary and secondary legislation, e.g., case law, constitutional law, international law, rules of equity? If not, what is the specific remit that they are given and agree to? Is there an overriding objective that adjudicators work to, as with CPR Part 1? Are the practice case management guidelines that adjudicators work to available as a public document? Are tribunals bound to uphold primary law, including the Bill of Rights 1689, Human Rights Act 1998, and international treaty conventions, e.g., European Commission on Human Rights, ICCPR? Finally, I would like to invite some observers to act as witnesses, as this is a public interest case. What is the procedure? Is there a view-only link that can be published so anyone can listen in, or do these attendees need to personally reach out and ask? I fully accept that a virtual hearing needs a limit on the number of attendees to be manageable. Kind regards, Martin Geddes. Thus the following response, and I am no longer dear to them. Mr. Geddes, thank you for your email of 17th January 2023. The function of the independent adjudicator is to consider the evidence and any submissions on the law, make findings of fact, and apply the relevant law to those facts. There are no overriding objectives under the regulations. The appeal procedures can be found under the schedule to the Road User Charging Schemes, Penalty Charges, Adjudication and Enforcement, England, Regulations 2013. Case management of the hearing is a matter for the individual adjudicator concerned, who must conduct the hearing of an appeal in the manner, quote, most suitable to the clarification of the issues and generally to the just handling of the proceedings, end quote. Any observer may contact the tribunal at help@trafficpenaltytribunal.gov.uk. They misspelled it. They didn't write out gov. And will be provided with the relevant link. Members of the public are welcome to observe hearings on the basis they listen only and do not attempt to take part. TPT hearings last approximately 15 to 20 minutes and connect within the Microsoft Team platform, enabling parties to self-connect via web or telephone. The observer will be emailed self-connection instructions for the hearing they have requested to observe. For additional information on our hearings, please visit trafficpenaltytribunal.gov.uk/what to expect at a hearing. Most people will pay the £12.50 clean air zone charge to get a quiet life. Of those who appeal, the vast majority are only interested in not paying the penalty charge. In my case, the charges themselves are an irrelevance. My only concern is to expose the unjust, unreasonable, and unconstitutional nature of these administrative tribunals. After all, as with the council tax, they have been condemned by the highest legal authorities in the past as being unlawful and a precursor to extortion. Now it's time to engage beast mode and really get to the heart of it all. Thank you once again for your prompt and efficient response, which addresses most of my questions. It is normal to correspond with a fellow man or woman. Do you have a name? My understanding, based on what you state, is that there are no written undertakings, training materials, or directions given to adjudicators beyond what is stated in the legislation empowering the tribunal. If this is incorrect, then please let me know. I do notice that you have not responded to the most important question, which is whether adjudicators have a duty to uphold the law, all law, including constitutional law such as the Bill of Rights 1689 and the Human Rights Act 1998, including reference to ECHR Article 6 on due process. In the absence of a duty to uphold the law, adjudicators have been given discretion to decide which law to uphold as most suitable to the clarification of the issues and generally to the just handling of proceedings in their personal opinion. This personal discretion opens the door to elevate statute law above constitutional and international law. This, in turn, appears to be an invitation to circumvent the law, daring the appellant to seek judicial review as the sole remedy to violation of his or her civil, constitutional, and human rights. In the absence of any statement to the contrary, I am presuming your acquiescence to the following statement. Adjudicators are not under a duty to uphold the law and are not under an obligation to uphold the Bill of Rights 1689 or ECHR Article 6. Section 16 of the regulations, recovery of amounts payable under an adjudication, states that tribunal adjudications are to be treated as equivalent to county court adjudications. This could be construed as a means of end-running the requirement for lawful due process in accordance with our Constitution. County court judges are under a public oath to uphold the law and are bound to act by their highest oath of public office. The difference would, on the face of it, compromise the enforceability of adjudications where matters of superior law are brought into play and not merely administrative fact, like a sign being unreadable due to being plastered with snow, for instance, but a PCN is still issued. In the event that an adjudicator not bound to uphold the law uses their discretion to violate my civil rights and aids the claimant to take what is not lawfully due, am I able to make a claim against the adjudicator? Is there a bond or indemnity insurance policy that adjudicators carry? Is my assigned adjudicator under any form of oath? Any other form of oath? This would include an oath to a private guild, which could be seen to be a conflict of interest to serving the general public. Finally, what are the rules on recording of tribunal hearings? Is there a facility for myself as appellant to have a recording as a matter of normal procedure in the Microsoft Teams platform? I believe that this goes beyond my individual case and is a matter of public interest. No doubt many others are affected in a similar manner. Given the potential impact on others and the general public, it is crucial to address these issues in order to safeguard the integrity of the legal system and protect the rights of all parties involved. Regards, Martin Geddes. It is only when you push back and hold them fully accountable for their actions that change happens. Until you assert your rights as a living and breathing man or woman with a soul, they will continue to take your tacit consent to slavery as a reason to financially rape you and destroy your inalienable rights. Clean air zones are legally little more than adverts at the side of the road, but Costa Coffee doesn't get to say 4 pounds a cup unless declined when you whiz past the motorway services and post you an invoice for nothing after the fact. The reality is that these charges are a form of fine or forfeit, and without due process, they are unlawful. They are being justified based on the hidden necromancy of demoting the living into legal fictions so that conscience and morality are no longer applicable. The state shows as evidence a vehicle crossing its boundary mark, but ignores that there is a man or woman at the wheel, and they deserve equitable treatment. It's all a massive scam, aligned to the fascist communist fusion of low-traffic neighborhoods and 15-minute cities via pervasive surveillance and control. The elevation of the group's purported interests over the individual's rights in order to enrich the administrative class at the expense of the public is contrary to our history and culture as well as the law. Time to revolt. That is the brilliant, incandescent Martin Geddes. He does this for a living. Go to martingeddes.com/support. You can support him all sorts of different ways. He lists them all. Just remember, this is his source of income. And what he does is time consuming and it's not cheap to do it. So definitely reach out. Go to martingeddes.com/support. You also need to go to epicthreads.tv. That's right. epicthreads.tv. Click on Angel Paste, and you can get the best lotion the world has ever known, made by patriots for patriots, made of only food-grade plant oils. And now you can get the Rose Angel Paste infused with the best rose essential oil in the world. You can get it individual bottles. It's going to be wrapped in red paper anyway, but it's going to be individual bottles. You can get that for your sweetheart for Valentine's Day. And when they're gone, they're gone. But guys, definitely get them because they are absolutely worth it. All right, everybody. That's going to be our show for today. Make sure to go to, one more time, go to epicthreads.tv if you can. It's the place where I want to try it out, and I want to try it out here first. It'll really save labor on our end if we're not constantly manually entering orders from the other system at angelpaste.com. So anyway, thank you everybody for being here. Thank you for watching. Thanks to the brilliant Martin Geddes. I will continue this saga until we catch up to the present tomorrow. Let us pray. Saint Michael the Archangel, defend us in battle. Be our protection against the wickedness and snares of the devil. May God rebuke him, we humbly pray. And do thou, O Prince of the heavenly host, by the power of God, cast into hell Satan and all evil spirits who prowl about the world, seeking the ruin of souls. Amen. I love you all. Thank you so much for being here, and I'll see you tomorrow.
I will be the greatest president that God ever created.